When we're creating a project, we often use videos, images, or songs that we download for free. Sometimes we don't even realize it, but those works are protected through copyrights. And therefore, what we're doing is actually illegal, even if we don't know it. That's why in this episode, we're going to learn about copyrights and how we use the content lawfully and safely. Let's go. What are copyrights? When a person creates an original work, that person automatically becomes the owner of the copyrights. It doesn't matter if it's literacy, scientific, or artistic. The work is considered a type of intellectual property that gives the owner the exclusive right. Ideas and abstract concepts are not valid. According to the legislation on copyrights, for a work to be protected, it must be creative and be embodied in a tangible matter. So what does that mean to the owner? Is it useful anyway? Of course it is. Copyrights protects two types of rights. Economic rights allows owner to derive financial reward from the use of their works by others. Moral rights allows authors and creators to take certain actions to preserve and protect their link with their work. The main difference is that the economic rights are transferable, meaning the author can sell them, assign, or share them with a third party. You cannot do the same with moral rights. What kind of projects are protected by these rights? We can only talk about this in general terms, as there isn't an exhaustive list in any legislation unless internationally. But amongst the works usually protected by copyrights around the world, you will find literacy works such as novels, poems, play, reference works, and journalistic articles, computer programs, or databases, films and their scripts, music compositions, artistic works such as painting, drawings, photographs, sculptures, architecture work, even advertising, maps, and technical drawings. Each one of these are intellectual properties subject to copyrights protection. But keep in mind that depending on the country you live in, the legislation on these rights can vary because of the international treaties and the directives inside the European Union. In order to use copyright work in your videos, there's only one thing you need: a license for it. As simple as that. How can you get that license? By contacting the company managing the economic rights for the work and asking for their permission to use it in your project. The common practice is that they give you a quote depending on the use. For example, if you're asking for a license for Justin Bieber's latest hit for a feature film to be released worldwide, it will not be the same as for a TV commercial for a corporate video. Anyways, you must contact the company managing the economic rights and ask for their permission. This process is tedious and, above all, not financially friendly for independent users. My advice is this: when editing your videos, never use songs of a well-known artist. Do you remember what we saw in the last episode? There are many libraries with thousands and thousands of amazingly produced sounds that can be perfect for your project. The license scheme is very easy, and so is the cost. As you can imagine, much more economical. That being said, the law establishes some limits and exceptions to copyrights, meaning there are situations where we could skip copyrights and use protected work without the explicit permission of the rights owner. Time limitations. In general, depending on the country, the economic copyright ends some years after the author's death. For example, in some countries in the European Union, copyrights protect the intellectual property until 70 years after the author passes away. This means that after the term stipulated in each country, the work will no longer be protected and will go into public domain. So anyone can enjoy and benefit from it. Okay, but what exactly does into public domain mean? It's very easy. It means that the economic rights have finished. However, the moral rights, meaning the author's recognition and integrity, would continue and be respected. For example, you can use one of Mozart's musical selections, record yourselves playing it on the piano, upload to YouTube, and monetize it. But of course, you can't say that Mozart's song was composed by you. As of right now, we don't have a worldwide public domain. Each country sets its own legislation, so you always have to consult on the specific law. In order to do that, you can find information on public domain in the Intellectual Property Registry of the country, or archive.org. Fair use. Depending on how we are going to use the work, we won't need to ask for the owner's right. For instance, if you're going to use the content for a cultural, scientific, educational, and research purpose, it's perfectly acceptable. But there is no universal definition for this limit. So each country's legislation has a legal doctrine that protects the use of the items under certain circumstances. Some countries will have a clear and specific list of the limitations and exceptions to copyrights, while in others just have a general clause, usually known as fair use or fair acts. You'll have to consult on your own country's legislation on the limits and exceptions to copyrights. The lack of an international legislation may be an issue, considering that we upload everything that is seen through the world. But don't worry, the international treaties have general condition. In case of a feud, each country must decide if the exception or limitation must be applied. Creative Commons. There are works not protected by copyrights because their authors renounce the economic rights and make available for free to the public. These licenses for common use are Creative Commons. You've heard about Creative Commons for sure, but do you know exactly what it is? Creative Commons is a nonprofit organization. It provides authors and creators, individuals, as well as corporations, a simple and standardized way to grant legal permissions related to the use and reuse of their works. By doing this makes it available in a very simple way. Creative Commons licenses are organized on a scale from less to more forgiving. 4 kinds of restrictions can be combined. All of them require a credit to the author. BY, credit must be given to the creator. SA, adaptations must be shared under the same terms. NC, only non-commercial use of the works are permitted. ND, no derivatives or adaptations of the work are permitted. Please go into creativecommons.org and consult the kind of license and its limits before using any material. If you want to obtain information on how to enter one of your works into a public domain through one of these licensing. Anyways, before using any work of your content, you have to pay attention to the specific terms of the license in order to know what are its precise limitations of use. I like to end this episode by clearing some doubts regarding myths and legends. If I give the credit to the owner, I can use the content. False. Giving credit to the owner doesn't grant you permission to use the work protected by copyrights. You can't use the score of Star Wars in your video and credit John Williams and pretend you're free of claims regarding intellectual property. You need to obtain the authorization from Disney Lucasfilm to the specific use you want to make. My video is nonprofit, so I can use whatever content I want. Sorry, but this statement won't prevent you from receiving claims for copyright violations. Just declaring your content is for entertainment or nonprofit is not enough. It's not an automatic defense either for possible claims. It's fair use. The courts will establish its legitimacy. If other creators do it, I can do it too. Other creators uploading videos with third parties' content does not mean they're allowed to do it. I bought it on iTunes, CD, or DVD, and I can use it. This is a private copy for personal use only and non-commercial, that's true. But if you upload a video to the internet, that's not true. Having bought the content does not mean you have the permission to share it on YouTube amongst other platforms. Saying no infringement of copyrights is on purpose. Sorry again. Any phrase or disclaimer such as, all rights belong to the author, no infringement of company rights is intentional, I'm not the owner, or even after the fact, I didn't know, does not apply per se that you are making a legitimate use of that material, neither that you have the permission of the owner. It's okay to use a few seconds of content protected by copyrights. The amount of content protected by copyrights doesn't matter. Even if it's just a few seconds, you can still receive claims for copyrights infringement. Even claiming fair use, remember only a court of law has the right to ascertain that. I hope I have been able to shed some light on this heavy matter. And remember, all the time and effort you made for your video will be useless if you can't share it on the internet because of an unintended copyright infringement. Besides, please keep in mind that copyrights not only benefit the authors, but society as a whole. Protecting the rights of the authors is an incentive for people willing to invest time and money in the creation of works. These creative works will enrich culture, markets, and economy, and ultimately ourselves. So you already know it. Respecting copyrights will be your contribution to a fairer and richer cultural environment. See you on the next episode.